5 seconds. Start. However, in spite of the notice having been served, one appears on behalf of the known applicant. The arguments made in the petition have remained uncontroverted. The arbitration clause does not indicate as to whether the arbitration is to be referred to a sole arbitrator or more than one arbitrator. Learned counsel for the applicant submits that the applicant would be satisfied if the matter is referred to the sole arbitrator. He has also submitted that it would be appropriate to nominate a former judge of this court. In my opinion, there is a valid subsisting arbitration clause. The non-applicant seems to have prima facie acted in breach of the agreement. The dispute seems to have arisen out of a bona fide arrangement between the parties. The arbitration petition also seems to have been filled within limitation. In such circumstances, I allow this petition and refer the dispute raised in this petition or any other dispute that may become available to the parties to the sole arbitrator. The non-applicant shall be at liberty to raise any counter claim if so advised. I hereby appoint Mr. Justice B.P. Singh, former judge of this court, as the sole arbitrator. The learned arbitrator shall be at liberty to fix his own remuneration and any other terms and conditions for the arbitration as deemed fit and proper at his sole discretion. The seat of the arbitration shall be in Delhi. However, the arbitrator may hold the arbitration proceedings at a place most convenient to the parties either within India or outside India. In our country also, when the Criminal Procedure Code 1861 was enacted, it was silent about the compounding of offence. Subsequently, when the next code of 1872 was introduced, it mentioned about compounding in section 188 by providing the mode of compounding. However, it did not contain any provision declaring what offences were compoundable. The decision as to what offences were compoundable was governed by reference to the exception to section 214 of the Indian Penal Code. The subsequent code of 1898 provided section 345 indicating the offences which were compoundable, but the said section was only made applicable to compounding the offences defined are permissible under Indian Penal Code. The present code, which repealed the 1898 code, contains section 320 containing comprehensive provisions for compounding.